The H1B Guy here, and today, the E3 visa, what you need to know. Did you know that there's over 10,000 E3 visas made available to high-skilled Australian nationals annually? But just over 50% of those visas have been issued in the last 5 years. In today's video, I'll cover the history and qualifications of the E3 visa. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube and like this video so that I can continue to produce more content like this for you. I also wanted to mention the H1B Guy offers a variety of consulting services. I help businesses and individuals solve complex work authorization issues in the recruitment process while bringing awareness to employment-based immigration benefits. If I can help you, please reach out. I'd love to hear how. Today's post is brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001, and also by Path to Canada, the ideal plan B for high-skilled immigrants currently in the U.S. whose status may be uncertain. If you're facing an H-1B denial or OPT expiration, don't get caught off guard. Make sure you have a plan B. Well, I wanted to jump right into the history of the E3 visa, which was signed into law May 11th, 2005 via the Emergency Supplemental Appropriations Act for Defense, the Global War on Terror, and Tsunami Relief 2005, which was introduced by Representative Jerry Lewis of California. Title 5, Other Changes to Provisions Governing Non-Immigrant and Immigrant Visas, Section 105, provides non-immigrant status for nationals of Australia with respect to whom the employer has filed labor attestations who are entering the United States solely to perform services in a specialty occupation. Limits approvals of such applications to 10,500 per fiscal year. So the E3 visa gets its roots from the Australia-United States Free Trade Agreement, known as the AUSFTA, that was signed between the two countries in 2004. But the E3 visa was not part of that language. It was later added to the Emergency Supplemental Appropriations Act for Defense, the Global War on Terror, and Tsunami Relief of 2005. So let's cover the qualifications as written. To qualify for an E3 visa, you must demonstrate, among other things, that you are a national of Australia, have a legitimate offer of employment in the United States, possess the necessary academic or other qualifying credentials, will fill a position that qualifies as a specialty occupation. For the purposes of the E3 category, a specialty occupation is defined in the same manner as in the H-1B context. A specialty occupation is one which requires the theoretical and practical application of a body of highly specialized knowledge to perform the occupation and completion of a specific course or higher education culminating in a baccalaureate degree, bachelor's degree, or higher degree, or its equivalent in a specific occupation specialty. Engineering, mathematics, physical sciences, computer sciences, medicine, and healthcare, education, biotechnology, and business specialties, etc. An example of this would be an individual obtaining an accounting degree from Harvard, performing an internship at a local auditing firm, and then being hired as an auditor for a Fortune 500 company. Very straightforward for those of you familiar with the H-1B visas and how the process of qualifying for one works. It all comes down to performing a role that qualifies for a specialty occupation and possessing a bachelor's degree or higher with a specific number of years experience per the job requirements. So what kind of supporting documents, or what I commonly refer to as evidence, will you need to provide? Well, your Form I-129 should include the following documents: a labor condition application, LCA, that indicates it has been filed to support an E3 classification, academic or other credentials demonstrating qualifications for the position, job offer letter or other documentations from the employer establishing that you will be engaged in a specialty occupation and that you will be paid the higher of the actual or prevailing wage. If required, before you may commence employment in the specialty occupation, you must have the necessary license or official permission to practice in the specialty occupation. The following documentation must also be submitted with the I-129. A letter from the U.S. employer describing the specialty occupation, the anticipated length of stay, and the arrangements for remuneration. Evidence that you meet the educational requirement for the specialty occupation, which must be a U.S. bachelor's degree or higher, or its equivalent in the specialty occupation, a U.S. Department of Labor issued certified labor attestation for E3 specialty occupation worker, proof that you are a national of Australia, and proof that you meet the general requirements to be eligible to apply to the change of status or extend status. So similar to an H1B, a LCA is required for E3 visas in order to determine prevailing wages for the Metropolitan Statistical Area, MSA, education evaluation, offer letter, complete job description with anticipated length of need, and compensation at or above prevailing wage determination. So let's cover the validity period for the E3 visa and maintaining work authorization in the U.S. So valid for up to 2 years per extension, no maximum number of extensions with some exceptions. To change employers while remaining in the United States, your new employer must obtain a certified labor condition application for the position in which you will be employed and properly file a Form I-129 petition. The Form I-129 petition must be approved before you are authorized to work for the new employer. USCIS may consider you to be maintaining E3 status following cessation of employment for up to 60 days during the period of petition validity or other authorized validity period. Note the Form I-129 is used to apply for an extension of stay or change of employment with the same employer. So the E3 visa can be indefinitely extended in 2-year increments, but the biggest catch is that the E3 must be approved in order to have work authorization. This can create issues for any E3 visa extensions or change of employers transfers. But now that premium processing is available for E3 visas by USCIS, as I covered in the H1B Guy news for the week ending March 26, 2021, it can help alleviate breaks in service that have been previously experienced by E3 visa workers recently if the petition or beneficiary is willing to pay the fee. So moving on to spouses and dependents, an E3 non-immigrant worker spouse and unmarried children under 21 years of age are entitled to dependent E3 classification. Your spouse is entitled to apply for work authorization, but not your children. To apply for work authorization as a spouse of an E3 non-immigrant, your spouse must file Form I-765 application for employment authorization. So E3 spouses can be granted immediate W-2 work authorization, but not dependent children. Coming across an E3 EAD is fairly rare for recruiters, but a few things to keep in mind is that they are issued for the same validity period as the E3 visa holder, and E3 EADs can perform any occupation and be paid any wage. And then wrapping up, an E3 non-immigrant shall maintain an intention to depart the U.S. upon the expiration or termination of his or her E status. E3 visas are not dual intent visas in the sense of H1B visas and L1 visas. However, an application for initial admission, change of status, or extension of stay may not be denied solely on the basis of an approved request for a permanent labor certification or a filed or approved immigrant visa preference petition. So, while not considered dual intent, E3 visa employees can be sponsored for an employment-based green card, and their change of status cannot be denied due to a request for perm labor. This is an interesting differentiation from TN visas, which are impacted significantly by the non-dual intent designation for TN visas when it comes to adjustment of status for employment-based preferences. And then the annual allotment. So as I mentioned earlier, there's an annual cap of 10,500 E3 visas. Spouse and children of the E3 principal are allowed to accompany the principal and will not count against that cap. Extensions of stay don't count against the cap either. According to the Department of State, from 2016 to 2020, there were 25,611 E3 non-immigrant visas issued, with 2020's 3,144 the lowest yearly total over that period. So averaging just over 5,000 new E3 visas issued annually over the last 5 years accounts for just over 50% of the annual allotment. Remember, extensions are not factored into this number, very clearly making the E3 visa an underutilized employment-based benefit. Several factors include this, but Australia's merit-based points immigration system and the tech boom experienced in Australia over the last 10 years are the primary reasons. With all of that being said, I've had the opportunity to employ several E3 visa holders over my career and find it to be an excellent option for high-skilled Australian nationals seeking an opportunity in the US and for US-based employers who are looking to tap into the global talent pool. For the full post on the E3 visa, what you need to know, please check out the H1BGuy.com. And a reminder that today's post is brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001. This national job board network provides recruitment websites in 1,024 major U.S. metro areas. Each local job board is its own portal and is a low-cost resource for immigration recruitment ads for all industries and professions with a flat price of $225 per ad regardless of which city you choose. RecruiterNetworks.com has been the #1 place for immigration attorneys, immigration ad agencies, and employers to meet the DOL requirements for the digital portion of the perm advertisement rules. RecruiterNetworks.com. Tell them the H1B guy sent you. This video is also brought to you by Path to Canada, which provides a plan B for high-skilled immigrants currently in the U.S. whose status may be uncertain. If you're an H1B facing a denial or OPT expiration, don't get caught off guard. Make sure you have a plan B. Path to Canada is your answer and will help you navigate the process. Interested in finding out more? Check out the link in the video description below. Wanted to ask you again to please like this video, subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications so that you're notified anytime we go live or post new content here to this channel. If you've made it this far, I just want to say thank you for taking the time to watch my video. I really appreciate your support. The H1B Guy, your global source for all things H1B.